Well, the villages, as we know, predate the Constitution, and the people, Hopi people have lived in this area for hundreds and hundreds of years, and for that period of time, the Hopis had to make decisions about things like this all along, and they have, and they're able to make this decision, I think, today, reassert that jurisdiction that they've always had.
Hopis have always had a way of working out disputes in villages. Clan leaders were often called upon to hear both sides of a dispute. Gigmungwis also help settle matters between village residents. Delford Leslie has been a judge for the tribe for 26 years, but he also has knowledge of the traditional ways because his father was Gigmungwi at First Mesa for many years.
When I was a young boy, I remember at our clan house, our uncles would get together and they would talk about issues of controversy. You know, they talked about it for hours at a time. And in the end, they made a decision. It's a well-informed decision. But you know, the decision they've made was respected by all the people that were involved because they were given an opportunity to participate in that decision-making process in a non-adversarial way. No one walked away from that really angry.
It can still be that way, even though the Bahana has come to Hopi and changed most of the traditional form of government. Past Hopi leaders knew enough to protect the authority of the villages. And so, under Article 3, Section 2 of the Hopi Tribal Constitution, villages retain their sovereignty in governing their people.
The idea for the Naquatzvewat Institute and for Hopi Dispute Resolution Services and all the services that we provide started from a concern expressed by Hopi village members and leaders themselves about the consequences of cases being brought to the tribal court that deal with issues that had been reserved to village jurisdiction, issues of property, issues of family, but that which villages were waiving their jurisdiction and sending them to court.
We're seeing an increasing number of complicated property disputes in the Hopi tribal court system, and they have been growing in number and in complexity over the last, I would say, 50 years. These cases are involving all kinds of questions with respect to homes, mobile homes, farmlands, lands that are undeveloped, and they're often disputes between Hopi people in the same clan, in the same village, and even between villages.
Munkapi, Upper Munkapi, is the only village throughout the whole Hopi reservation that has its own village constitution, separate from the Hopi tribe. So anytime there's a legal issue that comes up, yes, they can take it to the tribal courts, but the tribal courts will always refer it back to the villages. We had disputes regarding trailers moving into the village. We had disputes regarding the fields down in the farming area. And we had disputes, issues regarding families, child support, child custody. Those were some of the issues that we had to deal with.
In a case involving a trailer that had been moved into the village without permission, Hosova says they followed proper village procedure. The village determined the trailer needed to be removed, and even though the owner appealed the case in the Hopi Tribal Court, the village decision was upheld. When property disputes are left unsettled, it can put families in a bind, leading to infighting, diminishment of village sovereignty, and even run-down homes.
Because land assignments are a lot more difficult to get from the villages, a lot of times the primary land user may allow their children or another relatives to set up such a unit as this for temporary reasons, but they need housing. Housing is such a shortage here, so they need a place to live, so they can't, so they just bring in a unit such as this and set it up in as basic a way as possible just to have a roof over their head.
There's one particular case that came before the Hopi appellate courts that was a good example of how they can be very long and drawn out. This was a dispute over a bean field at Haute-Villa involving women in the same clan. By the time this case made its way through the Hopi courts, the parties had run out of money. They were still fighting. Indeed, they were probably more upset with each other. And there was no ultimate resolution in the case that anyone was happy with. This is a good example of what can happen to a land or property dispute case that comes into the Hopi court system today.
The founders of the Nequatzvewat Institute believe mediation could help these types of disputes.
That case could be now settled by mediation at the village level if the parties are willing to come to the table and work out a resolution that they can commonly agree to. It doesn't have to go to court. The Nequatzvewat Institute offers a number of important services to villages. These include technical assistance on setting up their own internal dispute resolution process, whatever the nature of that may be. This includes training village officers in how to be mediators.
Tuwa na walaya kakas ikapipan awuwan kakang yep tunal tika ima owi put itamangam itamamit itaw malay wisni Nequatzvewat nyo itamoy yaw hakawat kaspan wuwan to takamoy yaw titikay na yan ithi tahakim Nequatzvewat hi taaw ya nana mi ay kuye sen anta hi taaw nengam yekuya mantan.
Or we can work with the villages so that they refer disputes directly to the Nequatzvewat's mediators, who are also Hopi mediators. In any of these scenarios, we provide an avenue for people to work out their arguments, their fights, without going to tribal court.
The mediation service will work because it will take the pressure off of the CSAs or the village board to have to act as judges in these cases where they assert jurisdiction. Mediation services is going to allow the individuals to handle their own problems, to be able to communicate what they may not be able to do with a judge or with a village board where they're sitting in front of a group of people where they don't want to air out their personal issues.
In speaking with village leaders, they express both a deep felt desire to handle these matters, but a real concern that they can't handle issues of property and family in a way that will be respected by the tribal court, in part because they don't have a clear understanding and expertise of what the demands of the Anglo-adversarial system of the court is. So we work to bridge that gap.
We have Ordinance 50, which is the Family Protection Ordinance, and then we have Ordinance 53 that discusses family responsibility, the parental responsibility. And in those ordinances, they talk about gyaptsi, which is respect for one another. So we know that that is still at the forefront of our people.
I'm really happy that this project it's on its way, because it really helps to bring back, restore back to the villages the process that I thought we were losing, a way of life that would be gone forever. The court has been very supportive of this project all along from its infancy, and we'll continue to support the project. And we'll do what we can to work with all the folks who are involved in this project.
Isinod amam tumalay ta katubosi. This ima hakawat hi ta nami wukto ta hak amangay masin wuwan kyang amami pita pampai paspio katubosi nek ovi kasput hak tumalay ta nik hak nawus son kapas hi ta ang wuwan kyang pumoy amamami atang itapasi nang way kyang na nami aatote hi ta aw suan yekuya mantan nek ovi ima itam hakawat put tumalay yang nikam pa itam son kan noy nek pa pawan hi kya wis ni ita laway